Hey everyone, it's Deborah Whitson here. I hope you're seeing me. I was experiencing a little bit of technical difficulty, but I think I'm live now. Good evening, and I'm so happy that you are joining me tonight. Some of you may know me, some maybe not. Anyway, welcome to everybody. And I want to give you just a brief introduction, and then I really want to turn our attention to getting all of your questions addressed and answered. So, as you know, I'm Deborah Whitson. A little about me: I am an attorney in New York. I'm a mediator. I'm a certified divorce specialist. I began my law career almost 27 years ago. In the first half of my career, I was a special victims prosecutor. And I took the expertise and knowledge that I gained from working with victims of domestic and sexual violence forward with me when I went into the private sector. And I've been doing family law for the last half of my career, and that's a lot of years so far. I want to do the little legal disclaimer. I'm going to try to answer the questions that come up tonight to the best of my ability. But I want you all to know that this is not creating an attorney-client relationship, and I'm not giving anybody individual legal advice or individualized legal advice. In order to do that, I would really need to confidentially gather a lot of information, understand a lot about your situation and the background, and the jurisdiction that you're in. So understand that my knowledge comes from my knowledge of New York law mostly. And so my answers are going to be tailored to that, and where there are differences in other jurisdictions, or I know that you should be aware of differences that you should check in your jurisdiction, I will try to alert you to that. So with that, let's see. I have some questions that were submitted ahead of time, and I have some of my team on following us with us tonight, and I'll be taking some questions from them as well, or from you through them as you put them in the live chat below. So anyway, let's start off. I had a question submitted that said, can you share a bit about handling email badgering from an ex-spouse once our divorce has already been finalized? The person says it's kind of a gray area. How are we supposed to treat each other? And this is affecting our co-parenting relationship and our kids. So this is an incredibly common situation, unfortunately. So there are a number of ways that you can try to address this. First and foremost, in the course of going through the process of separating and divorcing, there may be agreements that get put in place, like custody and co-parenting agreements. There may be marital separation and settlement agreements. And certainly for many people, there can be court orders. So one useful way to address this is to try to spell out in a court order that you should treat each other very businesslike, with civil and respectful tone. We all understand that it's perhaps the rare separated couple that continues to be really close friends, or maybe even becomes better friends once they're no longer a couple. But many people maybe can't find that kind of warmth any longer once they're separated or divorced, but you certainly can treat each other in a business-like fashion. So I like to say that the parents should try to approach this as being co-CEOs of your children and their separate households. So if you wouldn't speak to a boss or coworker in a certain tone, and you wouldn't use certain colorful language with your boss or coworker or fellow CEO, then you shouldn't use it with your ex-partner and current co-parent. So if you have more issues about this, which is pretty common, having difficulty with co-parenting communications, I highly recommend an author by the name of Bill Eddy. It's Eddy. He has written many really readable, short and to the point books about a system he's developed for managing high conflict communications and keeping communications civil and productive, and deflecting the kind of anger, blame, finger pointing, and poking that people sometimes do, especially if they've had a difficult separation or divorce. So Next up, let's see what we've got. We got questions coming in. Um, let's see. All right. So I have another question that was submitted through the form. One is, can you share some reasons a court would get involved if there was neglect, like kids having a fight or different parenting preferences amongst exes, lots of threats to lawyers, etc.? Can you advise on how we should be handling these mini fights? So that's another good question. Again, I refer back to the Bill Eddy publications. There's some really good things in there about managing high conflict communications and working through co-parenting. So neglect in the legal world literally means neglecting the health, education, or welfare of a child. So hopefully parent conflict and the mini fights that the questioner asked about doesn't really rise to the level of neglect where child protective agencies or court intervention would be warranted or appropriate. But certainly co-parents have to navigate through these things and try to shield your children from them because, as you know, that's very, very harmful to the children to see conflict going on between the parents. So if you can't manage it yourselves by coming up with some communication boundaries and guidelines, seek out a good co-parenting coach. There's a lot of them out there. Even if your co-parent won't engage in co-parent coaching or counseling with you, a co-parent coach can give you some really good advice on how you can manage the situation to the best of your ability, minimize that conflict, and minimize the impact on you and hopefully the impact on your children. Using techniques to shield yourself and to learn to sort of deflect and not get drawn in to the tit for tat kind of stuff that may go on with unhealthy communications and mini fights. So I hope that answered that question. All right. Someone asked, is there a reason to change your divorce based on living in a new state? And if you move after your divorce, do you have to transfer or do something to accommodate your divorce judgment in the other state? And the answer to that, thankfully, is broadly no. So states are sovereign entities. Their laws are individualized, but in the United States, because we have 50 different sovereign entities, we say that court orders are given full faith and credit across every state and our U.S. territories. So technically, no, you don't have to change your judgment of divorce or file it anywhere, with two exceptions. If you need to modify your custody arrangement or order through the court system in your new state, or you need to modify or adjust family support, like child support or alimony, then you may need to register your other state's order in your new home state. And there's a different process in each state for doing that. It generally involves getting a certified copy of the appropriate judgment or order from the state that you got divorced in, and then registering it in the court that would handle custody or family support matters in your new state. So yeah, there's a process there. If you're not in New York, I'm sure you can do a little research and poke around and find exactly what you need to do in your state. If you're in New York and you want to get specific information about registering an out-of-state order in New York, shoot us a private message and we can give you some more specific guidance. All right. Let's see if we got any more questions rolling in. Okay, here's one. What should I expect in my first session of mediation? So that's a really great question. I'm glad that it came out. So I mentioned at the outset that I'm a mediator. I think mediation is an amazing tool for families. I hope some of the judges I appear in front of aren't watching, but honestly, family court is no place for families to be. It usually means that you can't come to agreements, you're warring. It usually means your children then are brought into the legal battle, often with a guardian ad litem or, in New York, an attorney for the child. And it just really kind of escalates the conflict. So I think handling your family matters and family disputes outside of court through mediation is a great option. In many states, you may be required to give mediation a try before you access the courts for custody, support, or divorce related issues. And I think that's wonderful. In New York State, we don't have mandatory mediation. We have a preference for alternative dispute resolution being made an option for the parties, and making sure the parties are aware and have referrals if they're interested in alternative dispute resolution. Mediation is one of the most common forms of alternative dispute resolution. So the question was, what can you expect in your first mediation session? So to a certain extent, that may depend on whether you're going into mediation with or without attorneys being involved. So I'm going to assume, since this question was asked, that the questioner didn't have or doesn't have attorneys involved. So if you're going into mediation alone, which again is quite common and nothing to be concerned about, then you can expect that your mediator probably sends you some information ahead of time with some questions to answer to give the mediator a background about your situation and your family and your finances. And the mediator may have asked you to come with some suggested outcomes or resolutions. So yeah, you want to think ahead of time about what it is in a range of options that you would find acceptable. Don't go into mediation with a hard and firm position on everything, because that's not what mediation is about. And try to go into mediation with realistic expectations. So if you wouldn't expect to get 100% of the marital assets in your divorce action, probably not realistic expectation to go into mediation and expect to walk out with 100% of the marital assets. But your mediator will set some ground rules. Those are ground rules of sort of good behavior and positive communications. So that makes mediation feel like you can count on it being a safe and neutral place. So there should be no name calling, no threats, no aggressive body language, things like that. And then the mediator will gather a little bit of information and will expect the parties to do most of the talking. Mediation really works best when the mediator is your facilitator and guide, and the parties are talking through options and trying to come up with solutions. So I hope that helps. All right, I think we have a question from Jody. I'm trying to monitor the chat and multitask here. Okay, guidelines for cohabitation. All right, this is a great one. Got to admit, in the past, I went into cohabitation, actually really long-term cohabitation, without even thinking about legal rights and responsibilities. So I have since become a big fan of, before cohabiting, setting out some expectations. Everything from who's going to do household chores, who's going to take out the trash, and who's going to clean the bathroom, whether you're going to put the cap on or not on the toothpaste. So from mundane things like that to much more important things like finances. How are we going to pay housing expenses? Will we commingle our bank accounts and use a joint bank account for some of the common living expenses? If you're bringing in kids or blending families, there's a whole lot of stuff to discuss there about boundaries, guidelines, parenting versus step parenting, expenditures, big expenditures for stepchildren perhaps. These are the kinds of things that couples often find, if they haven't thought about and talked through ahead of time, when the situation arises, it can unexpectedly lead to conflict. And you want to have your cohabitation be as harmonious and peaceful and stable as possible. You also want to be thinking, what if it's not? What if we both invest money in buying something like a big ticket item, a house, or we buy a car together, or we buy a timeshare together, or we, both pay for college for a stepchild? And what happens if that relationship doesn't last? Will you, get compensated? How will you divide those things? So that's when it gets really messy, or can. And that's where parties don't have the rules that you have surrounding dividing marital assets. There really are no rules in most states about how to divide the assets of unmarried couples. So you're kind of in uncharted legal waters if you can't figure it out. So the specific question now is, what do I need to do to avoid losing alimony? Okay, that's a good one. So in most states, alimony, by definition, will end on the remarriage of the recipient spouse. It can end on other bases too. Some states have a statute that deals with long-term cohabitation with a romantic partner, not a roommate. Those kinds of distinctions sometimes are fuzzy. But assuming you're in a state that has that looser, if you're in a long-term cohabitation situation, then you have to really tread carefully about that because you might trigger an end to your alimony. If you're in a remarriage state, then cohabitation shouldn't affect your alimony order. You also need to look at your alimony agreement and your alimony order in your state because some parties set their own terms for when alimony might be ended by some triggering event. So look first to your agreement, of course look to your state laws, and I'm happy to go offline if you want to talk about a specific situation, Jody. I'm happy to help you try to navigate through do's and don'ts in that situation. Okay, let's see what we have next. All right. Let's see. So, what do I do if I've been served divorce papers? That's a really good question. You might think that that's self-evident, but it's really, really important to make a note of the day, the date on the calendar, the time, the place, and the person, if you know, or at least a description of the person or the role of the person, like were they a deputy sheriff, for instance. All of those details, because believe it or not following your state's law on some of those things could make service of those papers improper and therefore of no impact. So in New York, you can't serve on Sunday or a legal holiday. So if you're served paper on Sunday, you can theoretically pretend you weren't served. That service is a nullity, or it's challengeable. It's able to be nullified, I guess I should say. So you want to make sure that you have all of those details and you provide that to your legal representative, because that could be a tool you can use to frustrate the other side, and it may render that service invalid. You certainly want to keep a complete set of everything you've got, and you want to make a call to your attorney or find an attorney as quickly as possible. There's usually short turnaround times for responding to papers, or you could be held in default. Default means that you, the other party wins and you lose, and you don't have an opportunity to even be heard. So there's a way to get in the door after default, but you don't want to be in default in the first instance. So contact an attorney. In many states, the time is as short as 20 days to respond to those papers. There are also special rules if you're served outside of the state where the lawsuit is brought. So if your ex is in California and you are in Oregon, you may have more time, and there may be different rules for serving when you are in a different state from where the court action is started. So make sure you give your attorney a complete set of the papers. Keep them clean and neat and able to be reproduced, so your attorney has everything that they're going to need in order to give you the best advice when you have that first initial consultation about those papers you've been served. But don't delay, because you don't want to leave your attorney up against a rush, and you certainly don't want to meet the deadline for responding to those papers. I hope that was helpful. Okay. Let's see. Do I have to sign a post-nuptial agreement if my husband presents me one? So, agreements require agreement. So agreements are voluntary. So whether we're talking separation agreement, prenuptial agreement, cohabitation agreement or postnuptial agreement or any kind of agreement, it takes two to tango. So short answer is no, you never, ever, ever have to sign any kind of agreement that's presented to you just because it's presented to you. So in that circumstance, I realize if your husband is presenting a postnup agreement, and from the tone of the question, it sounds like maybe you weren't expecting it, or maybe you weren't expecting the terms that were in that agreement. So that can put you in a tricky spot. Postnuptials can come about for a number of reasons. Maybe somebody inherited money, or maybe one of the spouses is now raising a grandchild who wasn't a grandchild of the marriage. So, there are lots of good reasons where couples envision staying together for the long haul, and they're going to have this postnup. A postnup can also signal that maybe there are difficulties. In any event, I think it's a great thing to present to mediation. Mediation is a good way to have open dialogue, openly share information about what led to the concept of entering into a prenup at that particular point, and to explore all the terms and options. So sometimes these agreements, I think prenups, cohabitations, and postnups can signal that parties are really just trying to get clear so they avoid confusion and maybe arguments over certain things, usually financial things. So it can be a good thing. So keep an open mind, get some advice, and if you don't understand the terms, certainly get a good lawyer, an experienced family court lawyer, to look at that with you. All right. Let's see. Is there a way to have a parenting plan set up where you have no contact with your ex? So, well, there's usually a way to do just about anything. And so, yeah, there's a way to do a co-parenting plan or a parenting plan where you have no contact with your ex. That would be required in many instances, like if you have a complete stay away, no communication order protection against the other parent, then obviously you can't have contact, and there will need to be things put in place that communications go through a third party, or exchanges of the children for transfer for parenting time happen with the facilitation of a third party. So yes, it's possible. It can be awkward and time consuming to put those things in place. So if you're trying to minimize the contact with the other parent, perhaps to reduce conflict that arises when there has to be communication, there are a number of things you can do to reduce the contact and communication with a co-parent. Sometimes we refer to that as parallel parenting, where there isn't a lot of dialogue. So in those situations, you definitely want to set up a very specific parenting plan, so that every week, day, holiday, vacation period, etc., is spelled out in your order. So there's no negotiating that or having to come to mutual agreement on those things on a ad hoc basis. You may want to have all exchanges happen on school days. So if you always exchange on Friday after school, the kids could go home on the bus to mom's in week 1 and to dad's in week 2, for instance. You can reduce the number of parenting changes. So a week on, week off schedule has fewer reasons to have contacts and fewer exchanges with the children. So that can be a way to minimize the contact with a co-parent. You can use co-parenting apps. There's some really great ones out there you might want to look into, and I don't get any money for these. I'm not endorsing a product for financial reasons or anything. Our Family Wizard, 2 Houses, it's the numeral 2 and Houses. There's a whole bunch. Those are 2 that I know that my clients have used from time to time over the years. They find them really useful. They have a shared calendar. You can link your school parent portal to the app. You can link your pediatrician's parent portal or patient portal to the app. You can track when messages are opened, when they're responded to. And a feature of our Family Wizard that I particularly like is it has a tone monitor on the communications. So what am I meaning by that? So if you say, hey, a-hole, you were late again in your intended message, the app will alert you that that tone is maybe not super friendly and ask you if you really want to send that message with that tone, or will suggest that you change your tone. So that can be just a good, mental reminder that in a moment when you're frustrated or angry or, exhausted or whatever, and you're about to send a message that maybe is not conducive to cooperative co-parenting, the app will alert you. It will nudge you. It won't stop you from sending it, but it'll nudge you that maybe you want to reconsider. So anyway, I hope that those are some thoughts on the topic. And I guess I'm going to say it again because maybe not everybody's hanging around for the whole session. Co-parent coaching. A good co-parent coach can help you through situations where minimizing contact with the other person or the other parent is desirable because of conflictual situations. All right. I like this one. Is it possible to get compensatory damages for the emotional anguish caused as a result of a spouse cheating? So, it is potentially available in certain states. I can tell you it's not available in New York State. But there are some states, and it's less an action against the cheating spouse than it is an action against the person the spouse cheated with. So, gosh, I'm trying to think back to my law school days because it's kind of old-fashioned and it's not very common. I think it's called an action for alienation of affection. And I believe it exists still in certain states. I want to say North Carolina might be one where alienation of affection is still a legal cause of action. I seem to remember that, or maybe it was South Carolina with a certain presidential candidate who fathered a child out of wedlock years ago. I'm not going to name names, but I think that the candidate's wife brought an action against the woman the candidate had an affair with. So, yeah, interesting tidbit. You don't see it very often, probably for obvious reasons. Oh, okay. Oh, here's another one. I really like this one, and I'm so glad it was asked. I want to get divorced, but I have 2 young children with my husband, and I think we should stick it out for the children. What are your thoughts? So I actually wrote a blog article about this. So here are my thoughts. One is I love happy relationships. I work in the unhappy relationship business, but I would much rather deal with helping clients have happy relationships. So if there is a willingness on both parties' part to really earnestly work at the marriage, and that usually means committing to using outside professional help. Go to a good marriage counselor, get some marriage or individual life coaches or something to help you. So if you're really willing to do the hard work and try to change, then yeah, go for it. I totally think that is a very smart thing to do. If you know the marriage is dead and or your spouse has no interest in engaging or working and doing the hard work to try to address or revive a dead marriage, then sticking it out for the kid can be a very, very bad example. It can, look, kids are sponges. They feel it, they know it, they see it, they hear it. So they're picking up on the unhappiness that's in their household. And over time, I think that must have a psychic impact on them, on their emotional state. You may be modeling to your child what a marriage is supposed to look like. And I guess if you ask yourself, if I saw my child as a young adult in the relationship that I'm in a relationship like the one that I'm in, would I be happy for them or would I be concerned? If the answer is I wouldn't want my child in the kind of marriage that I'm in, then don't model it for them, because you are modeling, whether you want to or not, you're modeling what a marriage should be. So I think that often it can be far better to model that everybody deserves happiness and everybody deserves to be treated well. And if you uncouple, separate or divorce, in a way that is respectful of your children's needs and in as harmonious or less bitter way as possible, like if you use mediation or collaborative divorce, I think that that could actually be a really good example for your kids. It teaches them resilience. It teaches them that sometimes things just don't work, even though we try hard, and it's okay to take care of oneself and do what one needs to do that. So I hope that helps. But I know it's a difficult and personal decision, and I think you'll make the right one. Okay. Erin, thank you. Yeah, so I am going to become a co-parent coach, doing a course in the next couple of weeks, and obviously a lot of background and helping parents navigate through that over the years in my family law. There are some good people in our local area, so my team will remind me to send you a couple of good names, but I have clients who have used a couple of people in our area and have had good results, so happy to share, and I'm glad you're asking. It's a real need in our area. Okay, let's see. I'm at the beginning steps of filing for divorce. What should I expect, and how long does this process normally take? So I guess I'm going to give you the usual legal answer. The safe legal answer is it depends. So yeah, this depends. It depends a lot in what state you're in. It depends a lot upon whether you're in an urban area or a suburban area or a rural area, because the court caseload can have an impact. And right now it depends a lot because of the COVID pandemic having affected, I think, every state's court system in a significant way, some courts more than others. So there was, for instance, in New York, a period of almost complete court shutdown at the very beginning of the pandemic last year, where very limited matters were allowed to be filed. So things stalled for a while then, and now there's a backlog and so on and so forth. So you might expect from start to finish, an uncontested divorce can take anywhere in a really, really expedient jurisdiction, 6 months. Some divorces take years. Some of that depends on how much you and your soon-to-be ex fight. Fighting about everything extends the time you're in court because you have more battles. You need the court's attention for evidentiary hearings or trials, which may take a block of time or a whole day or multiple days. And that kind of chunk of court time is in high demand and not widely available as much as it might otherwise be outside of a pandemic. So my advice to you is, if you want to move that process along quickly with the least amount of expense and the least amount of stress, then consider mediation. Mediation is much lower cost. Usually your mediator has a lot of flexibility to schedule sessions with you and doesn't have the backlog of months and months of work like the court system does, that you can usually get that process done in a matter of weeks or months, a few months, as opposed to 6 months or a few years. So sorry that I can't be more specific about that, but it's not a great time to be accessing courts if you're in a rush in the world right now because of the pandemic. All right. Let's see. Another question coming in. If I'm in the middle of starting a divorce action and I still have kids living at home, what is the best thing to do with them during this time? That's a really good question for your therapist, your divorce coach, or your co-parenting coach if you have one. And if you don't have one and you're just starting the process, I really recommend a good therapist that can guide you through this, and or a good divorce coach that can support you and give you this kind of practical advice specific to your situation and as things are happening. Kids can have a lot of different feelings during this time, and handling kids of different ages and age ranges can mean that you are getting kind of different reactions and having to respond to kids at a different emotional level, and dealing with a different kind of reaction. So young kids may have a real fear of separation and kind of attachment issues arising. Teenagers may be royally pissed that you're interrupting and disrupting their life and changing their routine. So you get the whole gamut of stuff. And so I guess I would just say you want to do what you can to minimize the conflict that they're directly exposed to. Um, Going through mediation and keeping things out of court so you're not warring with the other parent really helps to simmer down and keep that stress level and conflict level low. You want to reassure the kids a lot. You can't reassure them enough that they are loved, that they will still be loved, that they are allowed to be upset and angry at their parents. You want to shield from them any feelings you have of one party being to blame for the marriage or not. You just want to say, and you need to both be on this page. You just want to say, you know, we care for each other and we love you dearly, but we just can't, you know, get along as a couple, and we think it's best that we divorce. But you know, we expect you to love both of us, and we love you, and that will never change. That's got to be your message. It's very, very damaging to kids if you indicate that one party is to blame. And you have to be hypersensitive, I think, to the fact that kids tend to want to look at whether they're to blame in some fashion for this not working. So reassure, be positive, build up the other parent as the best parent in the world. That you got to act like that's your job. And they should be doing the same. But tearing down a child's parent is tearing down a piece of the child. So if you can't manage that while you're still under the same roof, then you may need to think about whether you stay under the same roof as you're going through this process. All right, sorry, that was a little preachy. I'm not a counselor or a therapist, and I don't even play one on Facebook Live. So please get professional advice if you have concerns about the emotional welfare of your children as you go through a divorce process. So, don't know if there's any more questions, and we've been at this for a little while. I'm happy to keep taking them if they keep rolling in, but I wanted to share a couple of things. This is brand new, and if you're watching me live or you're watching this on the replay, you are learning about this for the very first time, but I have recently become the first attorney in New York State to be licensed and trained to offer a program that is called Our Family in Two Homes. It is kind of a do-it-yourself, for the do-it-yourselfers out there, it's a kind of do-it-yourself approach to crafting your separation agreement and crafting a co-parenting plan if you're separating and you have children in common. Not totally on your own, but you'll have the support of a certified divorce specialist. I have a whole team of them in my office, and we are really trained to know how to communicate and support people who are going through life transitions, coupling, uncoupling, etc. And you get the benefit of my legal knowledge and my mediation skills as well, and pretty soon my co-parenting skills. And so what it involves, I don't know if you can see this really well on the camera, but it's a workbook that guides you through everything you need to think about if you're separating and you want to come up with your own separation agreement, which is, by the way, the path to an uncontested divorce. So if you have a good separation agreement and you've addressed everything you need to address as you are uncoupling, and you were married and you're now uncoupling, you'll have the document that you need to just get a paperwork, nobody shows up in court, low cost, low stress divorce. If you were never married, you can still do Our Family in Two Homes, because it deals with how are you going to divide up your finances. Well, what do you need to think about in terms of communication once you're separated? What about child support, custody, alimony, and everything and anything that you could think of. And the workbook has, topics for you to read, notes and things to jot down for, what are your values, what are your priorities, where you think you're going to have conflict and working through this with your soon-to-be ex, etc. I think it's amazing. I think for people who really want to have as amicable a separation as possible, at the lowest cost possible, with the least amount of stress possible, this is the way to go. And we're here to support you. So it's like the best of both worlds. You do a lot of work. We'll teach you how to use the workbook and how to get the most out of it. You'll do a lot of work on your own time and your own dime. But we're here to support you, answer legal questions, help you. So if you can do this as couple, you can both enter the Our Family in Two Homes course with us. It's an individualized, not a group course. So you either do it as a unit of one, you're doing it and you're hoping that it's going to help you negotiate with your ex. But ideally, if your ex is on board, you can do it together as you work through this process, and you really come up with your own outcomes with help and support. So it's kind of, the best of both worlds, because doing it alone, obviously, if you've gotten to the point that you've decided that you can't continue on as a couple anymore, there may be communication issues at play, and those may be hurdles to you satisfactorily resolving your issues without some help and support. Also, you may not have knowledge about what your legal rights are and how to make agreements that are going to stand up in court and be sufficient to get you an uncontested divorce. So I'm so excited about this. I hope you are too. I hope you spread the word to anybody that might benefit from something like this. I think it's going to save people a lot of money and a lot of grief. Also, if you are coupling, remember I said I love happy families too. We have a similar program, but it's for people who are either embarking on cohabitation, or they're engaged to be married, or they just want to get more intentional and thoughtful about their relationship. We have the Designing Our Future Together program, and it's similar. It asks you to sort of consider, how do you both approach finances? Are there issues of trust? Are there communication preferences and differences that we should just put out on the table so that we're aware of them and we can come up with ways that everybody can feel, or both of us can feel, heard and supported. So there's all sorts of really useful advice here. And I like to say that you wouldn't go into business with a partner if you hadn't talked through how you're going to manage the day-to-day affairs of the business, long-range plans, what are your visions as business partners for long-range plans, and how are you going to handle the partnership finances or the business finances. So you wouldn't go into partnership in a business without a solid plan and without a clear understanding with your partner. So why would you do that in a marriage? Because look, there's a lot more at stake in a marriage than there is in a business. So great options for you. I have a question. Do you accept insurance? How much do these programs cost? Okay, so, oops, I just lost the thing. I don't know if, like, some companies have a legal help kind of insurance offering, and I don't know how that works. So I'm open to it if you have a legal plan through your insurance, or you've bought a legal plan. I'm open to exploring that. I honestly, for those who don't know, I'm living and practicing in a pretty rural area, although with my mediation, I can mediate anywhere right now that people speak English, because I personally don't have bilingual skills, but we can get interpreters as well. So there aren't the same kind of rules with mediators as there are with lawyers. I can practice law in New York, but I can mediate anywhere. So I'm open to considering if there are legal insurance plans that would cover this kind of thing. As a mediator, co-parent coach, divorce coach, and attorney, counseling for mental health is not something that I'm able to take. So anyway, so our family had 2 homes for 2 workbooks, 2 people, and a number of hours of mediation and certified divorce specialist support. $2,500 flat fee, and we'll get you all the way through the program, and you should end up with a complete marital separation and settlement agreement and co-parenting plan if you have kids. Designing our future together is a $1,500 flat fee for 2 people to work together, again, with the support, expertise, and guidance. And if you want a cohabitation agreement or a prenuptial agreement or even a postnuptial agreement, if you're doing this as a couple that's already married but you really want to just kind of get clear on marital finances, we can do that too. So happy to consult one-on-one. If your situation is unique or different, we can certainly talk about customizing to fit your needs and your desires. Okay, there's another question. Oh gosh, this is one I hear a lot. How do you get your attorney to move your case forward, or what point do you start over with a new attorney? Okay, so this is, I'm gonna be really honest, and I don't know if any of my attorney colleagues are watching, and I guess I'm just gonna be honest. So when you hire anybody, you're hiring them to work for you. So yeah, you're hiring an attorney for their advice, and there are certain things that the attorney gets to have, final say on. Certain strategic moves, certain legal moves are, for your attorney to decide in his or her discretion. But most important things about your case, most importantly, any settlement, is yours to accept or reject. So your attorney can't force a settlement on you, for instance. But if your attorney isn't serving you, then you need to talk about it, because I'm going to go out on a limb and say you're probably paying that attorney a fair amount of money to serve you. And if they're not serving you, I think it's fair to, have an honest discussion and call that attorney out. Sometimes the attorney can't move the case forward because the court has no available dates. Sometimes the attorney is trying to move negotiations forward and the attorney on the other side isn't responding. So the more players and the more systems you have involved in the process, the more potential bottlenecks there are that your attorney may not be able to control. So keep that in mind. But if your attorney is the bottleneck, then I think it's fair to call him or her out on that and get straight on what reasonable expectations are for response times. That being said, there may come a time where the attorney and the client just aren't working well together, and that relationship should or needs to come to an end. That's a difficult thing, and I don't know that I can give you a blanket answer, because switching attorneys late in the game is hard on you. It's likely to cost you a lot of money because a new attorney is going to have to get up to speed on everything that has gone on before. So you're kind of paying for duplicate review of certain things. Your first attorney had to review things, and now your new attorney is reviewing. It's hard for the attorney to come in late in the game and try to hit the home run. I'm going to be honest with you. That's a tough spot to be in. I've been in it, and sometimes I've declined to be in that spot. I would say, if you feel you've hired a quality attorney and you're just frustrated that it's not moving along, have that conversation. Be honest, spell out your needs to your attorney, and see if you can come to a meeting of the minds and repair what's frustrating you, or get the problem satisfactorily resolved so that you feel you can stick where you are. If your attorney's bungling things, then you may need to cut and come up with Plan B. I hope that answer was helpful. I'm not sure it's always helpful. That's a tough situation. Again, if you are, if you want individualized advice, I'm happy to go offline and have a one-on-one. Just, message, and our team will be in touch with you, and we'll figure out a way to connect and get that question answered more to your specific situation. Okay, there's another question. I know we're getting up to about an hour here, so we won't go too much longer. If you file for formal separation with your spouse, do you have to follow through with divorce, or can you take time to figure it out and see if the relationship can stay together, or if you need to end it ultimately? That's a great question, and the answer is absolutely yes. So a separation agreement is a nice way to, if you're going to live separate and apart but aren't really sure that you want to go the next step to ending the marriage, it's a great way to resolve or clarify what you're going to do about children, custody and parenting, what you're going to do about family support, how you're going to divide up your finances and separate your bank accounts, etc., if that's what you're going to do. And you can stay separated forever and ever. There is no requirement that you ever file for divorce. And that might mean that you're holding on for hope of reconciliation, which is totally appropriate and fine in many circumstances. It could also mean that you want to keep family health insurance or keep your spouse on health insurance, and that's a legitimate strategy for doing that. So maybe you want to be separated and neither party wants to remarry, but somebody has a lot of health conditions and really needs that health insurance plan from their spouse's employment. Separation agreement will allow you to keep the health insurance in many situations, but not go all the way to divorce. So, let's see. There might be a couple more questions happening here. Okay, I think I got them. I don't know if my team can alert me if I'm missing any. I think I got all of the questions that were in the loop, either submitted ahead of time or submitted in the live feed. So I hope you found this useful. Comment in the comments below and let us know if you thought it was helpful. Let us know if you'd like to see more of this, or if there are topics that you would like to have a full session devoted to. I really love helping people and sharing this kind of information. I'm really passionate about helping people stay out of courts and controlling their own outcomes and keeping their kids out of war. I always say to my potential clients, I think it's the hallmark of insanity to let a stranger in a black robe make important decisions about your life and most importantly about your kids. No disrespect for the many good judges I've appeared in front of and regularly still do appear in front of. Judges are, by and large, really well-meaning and really try to get it right. But these are your kids. This is your finances. This is your financial future. This is your emotional well-being. Don't put that in the hands of a stranger if you can avoid it. And we're here to help. We've got a team of certified divorce specialists who want to help and guide you. So thank you everyone for your time and attention this evening. Really, really so grateful for all the really good questions we got ahead of time. And go have a good evening. Enjoy your evening with your family or on your own if you are happily uncoupled and moving forward to a new place. So good night everybody. Catch you online later.